Your names?
Travis Hawkins.
All right. You folks tried to resolve this matter or no? We're just going to go to trial. Pardon?
We attempted this weekend. I'm a did not come to resolution.
How close were the parties before we go into this?
Not very close, sir.
Hold on. This is about to turn into a procedural showdown. What starts as a basic landlord-tenant dispute is already showing red flags. When the judge asks how close the parties are to resolution, and the answer is not very close, that's courtroom shorthand for buckle up. This is going to trial. No handshake, no compromise, just strategy versus structure. And here's what makes this case interesting. It's not just about money. It's about timing, filings, and whether one side tried to change the rules right before kickoff. That late motion to amend, that could flip everything. So the real question is, did the plaintiff make a smart legal move or a fatal procedural mistake?
Peace.
Mr. Ellis, you'd agree with that?
Yes, Your Honor. The defendants do not feel that they owe any money.
All right. You sent something to Ms. Loudon. She's right now doing that.
I'm sorry.
She's doing that right now. You did?
I'm doing it right.
Okay. On the Lewis Loudon matter, only because she was here the last time, seemed rather intent on proceeding with the case. And I think it indicated she was going to get an attorney and do some other things. I'm going to we checked the courtroom, see she's not there. Going to try to send an email and to her, and I'll ask your patience. I'm going to do that because of an email that she sent regarding certain medical issues. So it'll be just a minute, but I won't hold you guys very long. Is that okay, Ms. Barton?
Absolutely, Your Honor. Absolutely.
Wow, what happened? She must have had a good holiday.
It's always a pleasure to be.
Yeah, I don't know. That's not. Check her ID. That's not Miss Barton. Okay. On this matter, then, this is the date and time set for trial on the Seminick matter. You ready to proceed?
Yes, Your Honor.
All right. Go ahead.
Your Honor, we have filed a motion to amend our complaint to include a complaint for damages, and I received no response from the defendant.
When was the motion filed?
You can go yesterday.
You guys get a copy?
That was addressed on May 21st.
I don't see a copy of a motion.
I can approach the bench and give a copy.
Do you see it in our thing that it was filed? You do? Yeah.
I have a note on May 20th, plaintiff submitted the motion to amend. Looks like it may have been filed in Saline. Do I need to reach out to obtain a copy? Do you need me to reach out to obtain a copy?
I've got one in front of me. When did you guys get a copy of this?
It was dated May 21st, 2024.
Say a few days
A
after
few
that.
days after that,
And what?
just before heading into Memorial Day weekend.
21st?
Yeah, this was dated May 21st.
For what date did you, the postmark? What is that?
Postmark on May 21st right here is the date that it was sent out.
So this is raising issues that they're entitled to answer regarding the security deposit.
This is where courtroom reality hits hard. Notice how the judge isn't arguing over who's right about the security deposit. He's laser focused on procedure. In civil court, you don't just win because your argument sounds fair. You win because you follow the rules exactly. Filing deadlines, notice requirements, opportunity to respond. Those aren't technicalities, they're safeguards. When the judge says this is a procedural problem, that's serious. Bringing in new claims at the last minute, especially involving something as specific as a security deposit statute, puts the opposing side at a disadvantage. And courts hate surprises. So ask yourself, if you were the defendant, would you feel blindsided right now?
Well, the lease provides that the security.
It doesn't matter what the lease is. I'm talking procedurally. You're raising claims regarding the security deposit at this late stage.
Well, they didn't leave a forwarding address, Your Honor.
Well, but that would precisely my point. They would be in, you haven't alleged that they haven't in this alleged amended complaint. You're just alleging a claim against the security deposit. Because I think as we were here at the last hearing, when we were talking briefly about it, they had indicated that they had provided a forwarding address.
I do not believe that's what they said. I believe
that is exactly what, is that what you said?
Yes, sir.
Your Honor,
No, I don't, just answer my question.
yes, sir. Yes, sir.
That's exactly what they said.
They did not, Your Honor. They said that he knew where we moved.
Mr. Alice, they said it the last time. I just said it. I asked them to verify that my recollection of what they said is correct. If you have a dispute regarding the facts, fine. But if you're telling me that my recollection is incorrect, you're wrong. They said it. You may disagree. That's fine. But that's an element of any claim against a security deposit, which is precisely what I'm saying. Procedurally, this is a problem. It's been pending.
Well, people-
They're entitled to answer, first of all, the motion to amend. And this is the procedural problem. They're entitled to answer the motion to amend. They haven't been provided. Was this mailed to them?
Yes.
You know, under the court rules, that's not enough time. You can't mail it. It says on the 17th. They don't get it till then. So they're entitled to answer the motion, and then they'd be entitled to answer the complaint if I were to allow them it to proceed. Folks, do you know what you want to do on the motion?
Sure, I've answered it, sir.
That was an unfair question. Um, Folks, do me a favor. Can you look at that amended complaint for me? And look at paragraph 3. You see it, the numbers that are there? All right. Without telling me why, because I'm not sure what I'm going to do with this yet. Are you disputing the electricity?
It's the electricity.
The electricity amount?
We had no recollection of that electricity until the last hearing. So we had no opportunity to even pay Mr. Stemmer back for that.
Okay, but let me.
I don't have a problem disputing that.
Pardon?
I have no problem disputing that. That's fine.
You have no problem disputing it, or you
Not-
have no problem with that
It's fine.
amount? Okay,
if we hear-
that's fine. That's fine. The $2,400 in rent, are you disputing that?
Yes.
The propane, which we talked about, is obviously in dispute. And as I recall, at the end of the hearing, you're disputing the paint damage. Mr. Ellis, why should I allow this amendment at this late date?
Pardon me, Your Honor?
Why should I allow this amended complaint? Because it raises new claims.
Well, I thought since they did not answer the complaint, we have the absolute right to file an amended complaint without leave of the court. And they never answered the complaint.
So the landlord tenant proceeding, they can answer orally. Jeez, oh Pete. Know the procedure before we walk in, counsel. Court's going to stand in recess. Sir, did you have a problem hearing?
Yes.
We have equipment that I'll have my staff provide to you so that you can hear the proceedings. Thank you.
All rise.
This right here is the turning point. A C8 motion sounds complicated, but the judge breaks it down beautifully. Even if everything you're claiming is true, your complaint still has to be legally structured the right way. That's huge. It means the problem isn't necessarily the facts, it's the framework. And here's the twist. Instead of dismissing the case outright, the judge gives them another chance. That's balance. That's restraint. He protects the integrity of the court while still allowing fairness. But let's be clear, this is the warning shot. The next filing has to be airtight, because if it's not, the door closes. Would you have caught that mistake before walking in a trial?
Court recalls the case of Samanek versus Courtroom and Meltzer. All right. Couple of things here. First thing is the motion filed before the court is, well, I'll say it this way. Usually leave is freely given to amend. This motion, the court could consider to be an untimely filing of the motion to amend the complaint, mainly because it doesn't. It changes the claims and makes a claim against the security deposit. There are certainly disputes, I guess, as to whether or not the Security Deposit Act has been complied with. Now, what that means, since you are operating in pro per, I would just indicate if it hasn't been complied with and wrongfully withheld, you could, under the Security Deposit Act, be entitled to double damages. That is one of the penalties under that act. Not saying that that's the case here, but it is certainly something that is within the realm of possibility. And that, quite frankly, would have been there absent the complaint, absent this motion to amend or the first amended complaint. So there's that. To try to get this matter resolved, and the court really is of two minds. One, given the timing of this and the setting for trial, I almost don't want to permit the amendment of the complaint. However, what would in effect happen is, in this court's mind, litigation regarding it would happen in any event, whether initiated from the defendants or whether initiated from the plaintiff. So my thought is to just get everything here and try to resolve it. However it gets resolved through trial, right? Having said that, the other problem then arises. So let me back up a second. So for you guys, that would be that unless you're objecting to the motion itself, you're then entitled to answer, which I would grant the motion. So let me make it easy, all right? So you don't spend your time with that. Then you're entitled to file an answer regarding the complaint, okay? And basically it's an admit or denial or put forth your position regarding each of the allegations that's in this complaint. Now, having said that, the problem with the complaint as presented to the court is that the complaint would not survive a C8 motion. And that motion, frankly, on the face of the complaint, because it involves the Security Deposit Act, doesn't state the necessary claims regarding the Security Deposit Act. Yeah. And I know I'm talking in legalese and I'm trying not to, okay? A C8 motion basically says that on the face of the complaint, just looking at the complaint, that the complaint fails to state a claim upon which relief can be granted. the remedy for that is not dismissal necessarily of the complaint out of the gate. It is to permit amendment of the complaint.
So here's what just happened. The court allowed the amendment, but with conditions. The plaintiff now has 10 days to file a properly structured complaint that actually satisfies the Security Deposit Act. The defendants get 10 days to answer. Trial is adjourned and reset. No one won today, but the judge made one thing crystal clear. Procedure matters more than pressure. This wasn't about emotion. It wasn't about who sounded more convincing. It was about whether the law was followed step by step. And that's the bigger lesson here. Courtrooms reward preparation, not assumptions.
All right. Got it so far? Okay. When a claim is made against the Security Deposit Act, there are certain, as I've indicated, certain requirements. Certain of those requirements must be pled, except to some very specific limitations within that act. All right. So what I'm going to order is this. And folks, if you don't understand anything that I'm saying, just because this is an awkward posture for this case to be in, but just go ahead and ask me and I'll answer it. I'm allowing the complaint to be amended, but I'm directing that plaintiff must file a proper complaint that would, at least on its face, withstand a C8 motion and properly state a claim upon which relief could be granted under the Security Deposit Act. Plaintiff is to do that within 10 days. Defendant then has, I'm going to require a written answer this time. Defendant to file a written answer to the complaint. Bless you. Within 10 days after receipt. Okay. So I need an amended complaint from the plaintiff. 10 days out. Once you receive it, even if that 10 days hasn't expired, you need to answer within 10 days of receipt. Oh. Then adjourn the non-jury trial to, will that give me enough time? What's today? I didn't count out my days. Today's 28. 10. 17. And then we have the 18th.
Yeah.
9 a.m. All right. Then I'll adjourn non-jury trial to, well, on the way out the last time, my understanding is there are nuptials that are to be occurring. So,
Yeah, Brian Michelle is next one, and a bachelorette party.
I don't want to know about a bachelorette party, but go ahead. What? So if I set it for June 18th, is that going to interfere with what you have? I mean, outside the stresses of everything.
The 21st of June. And I have to be in,
I'll have you out by then. What?
I have to be in Indiana. So I'll be traveling,
It's
but
not that far.
yeah.
Well, will you be traveling? Can you do the 18th and then
Yeah, I'll make
still get, you'll do it? Okay.
Yeah,
So non-jury trial, June 18th, 9 a.m. Okay. And then we'll proceed at that point, have your witnesses, have your exhibits, have everything available on the 18th. We're just going to try to plow through as much as we can. All right. Any questions from either side?
No, Your Honor.
All right. And Mr. Semenek, did that help you? Okay. So next time when you come in, just ask for it and we'll make sure you get it. Okay. Thank you. All right. That does that.
So,
Till 1 o'clock. All right. So court stands in recess.